We have a quorum. Let us call the meeting to order. May we invite the government team to come in.
Susan. 好，咁政府嘅代表。
Okay, the administration team has come in while they settle down. Could I draw members' attention to the fact that we have got a written response to points raised at the meeting on the 26th of February. We only have the English version of CB-21035-01. Maybe I first ask Mr. Chan if he has settled down to take us through that paper briefly, and then I'll see whether members have questions. Mr. Chan, can you walk us through the gist of the paper? Thank you, Chairman. Last time, some members said that in Clause 16 of the bill, we have put in a special arrangement for the HA and the D of H. It is said that the entire system is designed to include two tiers. Hong Kong people or patients can choose to join or not. When they join, they give a joining consent. And the second step is that they can choose private health organizations and then give the sharing consent to those. In other words, the OCMs or OHMs can be given the freedom to check on his health records with his consent. We have put in this arrangement in the clause saying that to the HA and DH, patients who have joined would be taken to have given the joining consent to the HA and DH, and this paper explains the reasons behind such an arrangement. In previous consultation, we have already stated that this will be the arrangement. There are a few reasons for doing this. Because to have this sharing platform, the purpose is to foster two-way sharing between public and private HCPs. And when we talk about the public sector, of course, we are talking about the HA and the DH. If we put in an arrangement that would only convenience the sharing between two private organizations, that has nothing to do with this sharing platform that we have built. This is one of the policy intents. Secondly, in the long term, we hope patients will be able to have a long-term or long-standing health record. Most people are now patronizing the DH or HA, and they are the biggest clients. And from the first injection or vaccination, a person may have his record kept at the DH or HA. So we'd like to continue with that arrangement so a person has his whole health record kept. If the DH or HA records are not included in a patient's record, then that record would not be comprehensive, not to mention that it will be not including all the information. And as you know, administrators or healthcare professionals at health organizations are very busy, and DH and the HA are particularly in this category. If we increase the workload by saying, I will give you the consent today and not tomorrow, there will be a lot of work pressure created. This paper introduces the background to this arrangement. And we are saying that based on the explanation, we'd like to preserve clause 16 as it is. This is what I like to say. I remember these two parts are related because some members have asked that question because they think that by removing clause 16, DHA and DH will not be automatically sharing the information. Now they think this is the way to do it, but let's see if members have further questions since we have already discussed this at length. Would members have some questions on the paper? I will allow 5 minutes for each member, including a reply. Dr. K.K. Kwok. Chairman, I don't quibble with this arrangement. I just like to know the scope. The DH and HA are involved in more public and private participation. In other words, say for example flu vaccinations, the information is already shared with private healthcare professionals. And also cataract operation and also prostate glands operation. And Mr. Ko-Wing-man has said that they will have to plow in another $10 billion for the purpose. The DH and HA may transfer the information to PPP, and the patient's particulars would have to be channeled to a private doctor for processing. When they do so, does it mean that would equate with clause 15 or 16 of the bill? In other words, that the record would be transferred through an HCP of the HA or DH. This person may not be a doctor. There may be some nursing care services or Chinese medical practitioner services, and these may be hived out by the DH or HA in the future. Would clause 16 apply in such a scenario? Secondly, what about the turnaround time? Say, for example, as I was saying, the DH or HA may hear from a patient that the patient may not want the records to go to a certain organization and he wants to opt out. Now, what is the turnaround time like? If I want to terminate the sharing consent today, how long does it take for that to become effective, that the instruction can go through? Mr. Chan. Thank you, Chairman. Thank you. 2 questions.
16條
Application of Section 16, how it relates to the public-private collaboration today. Clause 16 states that an HCR has automatically given the sharing consent to the DH to the HA once he joins this scheme. And actually, without that HRSS, I think some of the sharing is already being done now, and such information is now being shared in accordance with their agreement between the HCR and the HCPs. Now, if the HRSS is up and running in the future, we hope that in the long term, this such information in the public-private collaboration can be included in the system. We have to make one point clear. There are 9 types of information which can be shared, and these are all related to the health conditions of the HCR. Some of the information may be related to administrative purposes. For example, the use of a voucher, the remaining value of the voucher, and so on. And such information may not necessarily be shared in the future. So I just want to make this point clear. Clause 16 deals only with information which can be accessed by DH and HA. Will there be any cases where such information will be transferred out of the system, either with or without his consent? Now, for example, for PPP programs, well, this is actually what is happening. Some medical services have been contracted out to private practitioner or an NGO site such as Yan Oi Tong, Po Leung Kok, and their medical institutions. Now, the patient may have given consent to the HA, and then the HA has contracted out the services to an outside party. Does it mean that the information can be passed on to this third party, and there is no need to get consent again from the patient? So does it mean that the consent is automatically given to the authorized parties? Now, because I have joined PPP, although I have not given consent to this authorized party, that party can access my information. So is that party authorized to gain access to the information? Thank you, Chairman. Well, let me talk about two types of programs without HRSS. Some patients are already in the PPP, and HA may have to transfer data to some other parties. So that means the authorization is already there. He doesn't have to be given his consent again, right? Yes. Well, now with the HRSS in the future, and if the patient has joined this scheme or system, and through Section 16, HA can also be authorized to give out the information or share the information to another institution. So that's the implication of the bill. Well, that means the answer is positive, right? Yes. Well, there are two parts. Well, automatic consent. And the second scenario is when you join the PPP, then a patient may be asked to give consent to certain things like the kind of services, follow-up consultations, and so on. One of the conditions may be that the patient has to give consent that the patient records will be given to another institution which is providing patient medical services. I mean, is this an automatic process, or is there another procedure?
The other provider, whether they have automatic access to the patient's EHR record,
sure,
because they've joined this program. So
whether they need to have another separate consent.
They have to give consent. So whether the consent's bundled into the original agreement to join the program or not, they still have to give consent. So when they actually see that, if it's a as you said, an outsourced sort of arrangement, when they see that provider, they still have to give consent. Otherwise, that provider doesn't have it. The provider does not get automatic access to the patient record just because they're a member of a PPP scheme.
So may I recap what you have said? The first is that at the present moment, they need to have a separate consent. And in the future, again, they have to fill in another separate consent in order to get access to the medical records.
All access to the EHR from a healthcare organization requires explicit consent.
Okay.
So even if it's PPP, PPP is just a mechanism to share the data.
So this, even in the case of an outsourced vaccination plan and things like that.
To get access to the HRSS, the patient must give consent to that.
So that means this 16, Article 16 is not applicable to, a kind of automatic consent.
Yes, yes.
They need to have a separate consent for that. Yeah.
This does not give automatic consent in an outsourced situation. Yes.
Okay. 咁答咗啊。第一部分
turnaround 個時間。
Second part of the question, turnaround time. If the patient says that he would like to withdraw from the scheme, then we have to make verification, and we have to see that is it a patient in the system and the SDM is eligible or not, and then there may be some procedures to go through. And then I think the process will be relatively quick. Do you have a specific period in mind? Any performance pledge, so to speak? Turnaround time.
The process, the technical process should be quite quick. Of course, it's just a computer system. There may be some. Because we haven't done it yet, so because of the administration, of course, you have to maybe verify that the person's actually the person, that sort of thing. So a matter of a day or a couple of days, depending on any administrative overhead. The actual technical, it's just a switch, so it should be quite quick.
Will you consider to put in a commitment?
主席，如果係咁咧，我就希望咧將來個法例行嘅時候咧，當然。
Well, if there is legislation, I think there should be clear administrative procedures set out telling the patients what will happen when he makes that request. Now, if you want to attract people to join this system, you need to have a transparent mechanism. There are two things involved. Now, if the patient gives a consent, perhaps then his system is effective in, say, a couple of days. And then second scenario, when he withdraws the consent, then you may also like to have a service pledge for doing that, for termination. So, can you do that? Well, that should be okay, because what we need to do is just to verify the eligibility of the patient. We can do it within 1 day, and perhaps in the patient's notification and service pledge in the future, we would lay out the rights and obligations of the patient. Yes, so these are the answers to Dr. Kwok's 2 questions. So does any other member have any question? Ms. Elizabeth Kwok. Well, there would be a problem in removing Clause 16 after reading through the government's paper, so I support not to remove the clause. The legal advisor last time has also raised a number of questions. So perhaps I'll ask the legal advisor to take us through, and then we'll discuss that before we go into clause by clause. Thank you, Chairman. Last time, the Chairman asked me to make some studies. Without the patient or the SDM's consent, can healthcare professionals count on the exemptions of the PDPO and gain access to the information in the patient's records? I noticed that there are 2 sections in the PDPO which are related to exemptions which may be applicable. The first one, the letter that I wrote to the administration is paper number CB bracket 2956/1415 bracket 01. There are 2 sections related, section 56, which are related to health. In order for that exemption to apply, we have to prove that the case would likely to cause serious harm to the physical or mental health of the data subject or the individual. The other exemption is section 63C, which relates to emergency situations. And we have discussed this section in the last meeting. Well, our interpretation of these 2 sections differs from the administration's. The government cites emergency rescue operations, and their conclusion is that that covers the situation that I mentioned. But I used general interpretation of the law, and that is when there are two clauses in the same sentence, we cannot just look at one phrase, two phrases in the clause, and we cannot just look at one phrase. And when we look at the clause again, it says carrying out of emergency rescue operations or provision of emergency relief services. And that should not be covered just only the doctor's carrying out emergency services on a patient. So we have to look at also the emergency rescue operations, the phrase before it. So if there are disputes in the interpretation of the law, and normally we would take the case to the court, and the court will make a ruling. The court tends to be taking a stringent view on the law. Exemption only applies when the law is the law provisions, legal provisions are very clear and express. If the clauses are not specific enough, the court will likely not grant any exemption. Now we see that there is a gray area, as what I mentioned, and that is whether these two sections of exemption can apply. Would it be a more preferable approach in that in the legislative process we provide for an express exemption in the bill to cover the scenario? So, Mr. Chen, you have already responded to the paper, so can you take us through your views? Let me first clarify. In June 2014, 10 months ago, we discussed this point already. A member asked, in an emergency situation, a doctor without the patient's consent, whether he could access the information of the patient's record in order to do the emergency treatment. So at that time, we said that according to 63C of PDPO, we could allow the doctor to access the personal data for giving treatment. So that's why we invoked 63C to try to explain the situation. And because maybe the patient has fainted and it's impossible to get the consent, so we should use 63C to carry out emergency treatment. Last time, the legal advisor also said that Section 59 is also relevant, because Section 59 says that contains a word likely to cause serious harm to the physical or mental health of the individual. Well, I just want to explain that we didn't mention this clause because the other time question was raised on emergency situation. So our response this time is that we agree that Section 59 is also relevant. And if a healthcare professional, without the consent of the patient, can access the data so that if he doesn't do that, it will cause a serious harm to the physical and mental health of the patient.
Even without the bill, this is allowed. And doctors rely on this section to do this, even today. So we are saying that since there are exemption clauses already in PDPO, it is not necessary for us to repeat that in the bill and to restate the authorization that is already in PDPO. Our bill says that if we do not follow the PDPO, then we would provide for it in an express manner. And then we have already said that if we follow the PDPO, we are not going to restate that in the bill. We also agree that Section 59 is relevant, and that is exactly what we are saying. Since there is already authorization or exemption provided by Sections 59 and 63C, we don't think we need to repeat that in the bill. Okay, so you are saying it's not just 63C. This is the background to the question. You are telling us that both 59 and 63C would apply. Legal advisor, what is your view? Are you still of the view that we should provide for it expressly in the bill, or is it that if 59 also applies, then it is all right? I think I have already stated my view. Members, what do you think? Dr. Loai Kwok, Chairman, I'd like to ask Mr. Chan for clarification. 63C and also 59. I think what you were trying to say is not just about interpretation or understanding of the law. You are actually telling us that these already apply in the present situation. I ask this because if we are only at the interpretation or understanding stage, then maybe it is up to the court to interpret the law. But if you are telling us that this is already happening, I think we are not that worried. In other words, even if you do not have an express exemption in the bill, sections 59 and 63C of PDPO already apply as they do now. You mean under PPP, we can also invoke these two sections, is that right? So that doctors can seek patients' records for treating patients. I think that's what Dr. Low is asking. Mr. Chan, thank you, Chairman. Let me talk about the law now. First, we do not have the sharing platform. We do not have the EHRSS yet, and the bill, therefore, is not effective at the moment. Right now, if a person wants to access another one's private record, you have to follow the PDPO whether or not that person is a patient. And in the PDPO now, there are two sections which would allow a healthcare professional to access a patient's record without the patient's consent. Now, would the professional be breaking the law? The PDPO says there will be exemption if you comply with Section 59 and Section 63C. And in Section 59, the title is health. In other words, if the records are not accessed, there would be likely serious harm caused to the physical or mental health of the data subject or any other individual. In other words, if you do not access the record without consent, then serious harm would be caused, and therefore the healthcare professional will have exemption and will not be breaching the PDPO. Section 63C is more specific. It talks about an emergency situation. In 1C, the carrying out of emergency rescue operations or provision of emergency relief services. So even without the consent of the injured or the victim, the person would have to access the record first before emergency relief can be provided. This is very specific. In other words, the persons giving care in an emergency situation will be able to explain why he accesses the records without consent. Since these two sections are already in the PDPO, they are effective provisions. If somebody takes the healthcare professional to court, the professional can cite these two sections to state his case at the court. In other words, we already rely on these two sections for exemption. But I can't tell you whether such cases have taken place in the court. Maybe there have not been such cases. But since these situations can crop up every day, in a traffic accident, these are the exemptions in the law. Dr. Low, I can accept that explanation. I therefore agree with the reply that it is not necessary to add express exemption clauses to the bill. Any other views, members, on this paper? No? I think we can continue with clause-by-clause examination of the bill. I'd just like to mention that you should have received a letter from Dr. Fernando Zheng, and that is he has asked for a written reply to the paper on substitute decision maker. We haven't got the reply yet. We have discussed that many times, and I believe Dr. Fernando Zheng just needs something in writing from you. Dr. Zheng is not at the meeting today. We're not going to discuss his letter again. I hope you will give the written reply next time. Let us now continue with clause-by-clause examination. I think we have completed clause 18, and we should start with 19. Thank you, Chairman. Last time, we were talking about registration by private healthcare providers. We'll continue today. Yes, Ms. Quat. Last time, I was in a hurry to go, and I'd like to ask a question on 16 and 16A. I'd like to confirm again. Will it be that with 16A, since that is for the protecting of patients' privacy, would it be that we have 16A but it will never become effective? Mr. Chan. Thank you, Chairman. In previous meetings, the administration has already promised that when we start stage 2, we will immediately conduct a study to add more functions so that the patient will have more power to limit what information will be released. We have already committed to do that. When we study the functions to be added, we will also seek the consent of stakeholders and members. And when we have your consent, we will invoke new section 16A. Because 16A is about powers to limit sharing. In other words, to pose sharing restrictions. That is how the schedule will be. We have to conduct the study first and then can decide what new functions to add, and then we can promulgate 16A so we can kickstart the new function. Ms. Quat? Yes, okay. I just like to say that it should not just be left there. What he means is that there will be consultation and consent has to be sought first. But let me ask you again, when you say it will become effective, does it mean that there will have to be consequential amendments to other sections of the law then? Because it may lead to consequential amendments. Well, for the time being, Section 16A, if it is enacted, will afford us a lot of flexibility, and we don't see any necessity to do consequential amendments because the administration will be given the power or authority to design new functions, so the patient has more powers to choose what to share and what not to share. So my view is we will just allow 16A to become effective. Would there be procedures that you have to take before 16A and B can become effective? Do you have to give a notice for commencement? According to the first few clauses of the bill, the Secretary for Food and Health will have to gazette the commencement notice, and so that 16A can commence operation. Okay, right. Thank you. We can continue with 19, please. Amendment of registration. If a private clinic or hospital has done registration, but somehow the registered information has to be amended, it will have to follow clause 19. Now, when would the registration have to be amended? 1A says there is a change in the particulars of a service location. Maybe it has not moved, but the building or the street or the estate it is in has changed names. So because of 19.1a, the registered information may have to be amended. And B talks about a moving of the service location, maybe from Sha Tin to Tai Po, so it has to change the registered information. 19.2 to 4 have to do with the fact that the healthcare organization must still comply with all the specifics of the scheme, even when it changes its location or name. Say they still would have to have the the right type of healthcare providers, and he has to provide a computer system, and then he also has to comply with the procedures for making that change. When we receive notice, we will state in writing that we have received your notice, and that can come into effect on a certain date. So 19 is quite technical. It is a technical provision to regulate the amendment of registered information. Any questions? Please continue, Mr. Chen. 20. We have already said that there should be changes to 20. We have written here that the commissioner, if he is of the view that a government bureau or department, we're not talking about private providers here, if the bureau or department can be registered to become a healthcare provider for the system. Now, we thought that apart from the DH, there would be other departments that provide healthcare services, like the Correctional Services Department and Immigration Department. If people are held in custody for protracted periods of time, we will provide healthcare services to those people as well. And therefore, we thought that the CSD, for example, might have to be registered as a healthcare provider in the system. So the healthcare professionals at CSD can also access the records. This is the original intent behind Clause 20. But then the PDPO, or actually the Commissioner for Privacy, has commented that maybe Clause 20 is constructed too loosely, and we have agreed to changing it. And we agree that no bureaus are involved, but there are departments who are involved, like the CSD. So perhaps we would cross out the word bureau. And then private providers, we will state very clearly that they have to engage healthcare professionals before they are kept in the category. But these words are not in Clause 20 yet, and we agree we have to add that in. In fact, the departments we have in mind, like CSD and the police, they are already providing healthcare by qualified professional at their institutions. So we would just write in that these people should have the right qualifications, and we agree to move CSAs to Clause 20. Members' questions? Dr. Helena Wong. If you are going to amend Clause 20, do we have the CSAs with us? Yes. We have the paper.
CB 括弧2986/14至15號文件。
That's in paper CB 2986, bracket 01. Can someone find a copy for Dr. Wong? Maybe there are many papers issued already and you may not have it with you.
Can Dr. Helena Wong spend some time to take a look, and then we will continue with Clause 21. Clause 21 is simple. And the private healthcare provider joins the scheme on a voluntary basis, so they can withdraw from the scheme naturally. So Clause 21 provides for the withdrawal of the private healthcare provider from the scheme. And the request must be made in the form and manner specified by us. And after granting a request, we will notify them in writing of the date on which the request is granted and the effective date as well. So this is a rather natural procedure. Members said that you would come up with a performance pledge, right, in the future. So this has to do with the healthcare provider. HCP, would you come up with a performance pledge also? Yes, we will say the same thing. Then say in normal circumstances, we would your request for withdrawal will take effect on a certain date, some days later, and so on. If the HCP has not made a request for withdrawal, but then his business closes down, how will you deal with that? So that will be dealt with under clauses 22, 23, and 24. 22 is suspension of healthcare providers registration. It says here that if the commissioner suspects that the HCP is in the following scenarios, then he would be suspending the registration. And this covers that the HCP is contravening the provision of this ordinance, and also a provision of a code of practice, and also maybe the HCP contravenes a condition for the registration. For example, the HCP may promise that a certain type of computer system will be provided and a certain number of professionals will be engaged, but that is not found to be the case. So maybe we have to suspend his registration. BCD has to do with, say, the removal of the service location without our notice. And C, the HCP doesn't meet with the system requirements. And D, the nature of the business has changed. So if we have reasonable doubts on these matters, we would be suspending the registration. The commissioner would notify in writing of the suspension and the date on which the suspension takes effect. So that's clause 22, bracket 2. Bracket 3. During the suspension, the HCP can do certain things and can't do other things. And that is the new data of the HCR may still be provided by the HCP to the system, but then he can't access it. We want to protect the interest of the patient. When during the suspension and the patient is still using the service of the HCP, and then ultimately a couple of months later, the HCP is found to have no problem. So we don't want to see the situation where during these 2 months, the patient's records will go missing or is not put into the system. So that's why we have 3A. But conversely, the HCP cannot access the information in the system. That is to protect the interest of the patients. Bracket 4, after the investigation, the commissioner will notify the healthcare provider in writing of the commission's decision and whether the suspension will cease to take effect. So that's for bracket 4. So this is about it for suspension of healthcare providers registration. Can you continue with 23? And 23 is outright cancellation. And maybe after 22, we found the cases to be serious, and we may have to outright cancel the HCP's registration. If the Commission is satisfied that the HCP contravenes a provision of the ordinance, a provision of a code of practice, or a condition for the registration, or he no longer provides any service, or there are problems with his computer system. So in these scenarios, we will cancel the HBC's registration. And based on 23.2, we would notify the HCP of the cancellation, when it takes effect, and the reasons for the cancellation. Dr. Elizabeth Quat. Thank you, Chairman. If a doctor joins a scheme and the system and his license is temporarily suspended, what will happen? What are the procedures like? Mr. Chen? If the doctor opens his own clinic and he applies for joining the system in his own name, our requirement is that the clinic must employ someone who is eligible to provide medical services. If the doctor's license or registration has been removed, then his registration will also be suspended. What about this case when there are several nurses in the clinic? Now, if, say, there are a few doctors and a few nurses in the clinic, then even after the doctor's registration has been removed, then the clinic's registration will still be valid. But how do you know? Would you have any ways of finding out whether a doctor's registration has been removed from the register, or is it that the doctor is obliged to tell you that when he is no longer a qualified medical practitioner, he must tell you? So would you be having sharing of information with the Medical Association, Medical Council? Yes, we do have ways to know about these matters. Whenever a professional has to access our system, we will check the common professional list to see whether he's on the list, and that contains a list of all the registered members of the 13 professionals. And we can look at the system, and then we can check whether he is on the list. Yes, well, we can check the individual. So that covers not only the doctors, but also nurses, and also the 13 professions. You would check in every case, right? So, Chairman, you're talking about 13 common professionals list. How do you update the list? Is it done on a regular interval, or is it sort of instantaneously being updated? Is the list updated for the 13 professions? Ms. Chang. We work with the Secretariat of the DH, which is looking after boards and councils, and we've held many meetings with them, and they would be passing us information regularly on professionals whose registration has been suspended. Actually, investigations on a healthcare professional normally take a long time, and once the results of the investigation are gazetted, then we will be notified instantly. So we will be updating very promptly. So regular, what do you mean by regular interval? What is the time like? Once a month normally. If there are certain incidents, court cases, and so on, and they are about to get set the revocation of the professional's license, and the information will be passed to us on an ad hoc basis instantly. The DH will be gatekeeping, right? And if the DH knows that somebody's license is going to be revoked, it will be notifying not just you, but also other government departments as well. So can we assume that the DH will be handling this very quickly? That's what they've done in the past, right? And does it mean that when the commissioner receives such notification, he will block the system instantly? He can't upload the information and he can't get access to the information. I mean the professional, right? And whenever a clinic, a professional joins the system, we will lay down certain conditions and we will tell them that they would have to notify us immediately whenever licenses are revoked, locations change, there is a change in locations, etc. So if there is only one doctor in one clinic, does it mean the registration in the system will be cancelled automatically? Well, if the nurses' license are not revoked, the nurses can get access to the information. Well, why is this happening? If a doctor's license has been revoked and he can't use the system, why are you allowing his nurses to use the system? For one private clinic, there may be several doctors. Well, I'm talking about one doctor and several nurses. One doctor, two nurses, or one physiotherapist. Perhaps these other healthcare professionals still have to keep providing service to the patient. For example, reminding the patient to get medicine and so on. So that's why we would not be barring the other qualified professionals to gain access to information, even if one professional in that clinic's license is being revoked. As we said, we have this principle of need to know. And last time, we promised that we would add in an extra clause saying that the healthcare professional can access the information on a need-to-know basis. Even if you are a licensed professional, but you are not treating the patient, then you don't have the right to access the information. If the clinic has only one doctor and the doctor's license has been revoked, can he still continue with his business? Is this what's happening in cancellation and suspension? We cover a number of scenarios. For example, if the business nature has changed altogether. For example, a healthcare clinic has been turned into a food factory, then the business nature has changed. Well, if a doctor license has been revoked and he is the only doctor in the clinic, does it mean that the clinic has to close down, can no longer be in business, right? Well, but this is not what Mr. Chen said. Mr. Chen said that even if the doctor's license has been revoked, the nurses in that clinic can still access the system to remind the patients to take medicine and so on. I'm not familiar with the situation. Is it the case that even if the doctor's license has been revoked, the clinic can still go on business?
I can see. Well, I cannot speak on behalf of officials, but I think that in the system, in the private market, there are three ways of operating. One, private hospitals, two, HMOs, where there is a group of professionals. If one of the doctors of an HMO has his license revoked, then there are other people in the group who can take care of patients. Well, that I understand. But if there is only one private clinic with one doctor, like Dr. Kwok, touch wood, I'm not saying this about Dr. Kwok. Well, anyway, if he closes business, for example, then what about his staff? It has a business registration. As you know, clinics are not exactly regulated. The bureau chief says there is regulation, but then they only have business registration. If the boss goes away, the account is closed. And the physiotherapists and registered nurses registered PTs, they are governed under this bill. They will have no way to access EHR records because the boss has gone away. This is the actual situation. And also, there are other likely or possible extreme situations. Is it that you want to cover each and every scenario? If not, are you saying that those extreme situations will not happen? Because I'm afraid we are digressing from the scrutiny of the bill. Maybe, are we talking about management of clinics? Dr. Wong, would you like to say something? I agree with Mr. Lee. The medical council or the 13 professions, they have their own registration board. If a license is revoked for a professional, it is about a personal conduct. That person should not be providing health care to patients, but we are not talking about the organization. If a clinic is registered in the name of a doctor, and the doctor provides health care, but his license is revoked, saying that he should not provide health care, then two scenarios might come to pass. First, the clinic will not be in business, and according to the bill, if the business nature has changed, if he doesn't provide health care anymore, if he does not employ qualified professionals to provide health care, then he cannot be registered as qualified healthcare provider in the system. Mr. Lee is also right in saying that the doctor himself may not be providing health care. The law does not say that he cannot continue operating the clinic. He can still allow professionals at his clinic to provide health care. And in our system, the registration should not be affected. And as we explained, the clinic may continue its operation, but every time there is access made to the system, we will check whether that person is still validly registered. Any more questions? Legal advisor. Chairman, I wrote to the administration to inquire about the commissioner's power to suspend or revoke registration. And before that, that is, before the commissioner exercises his authority to suspend or revoke registration, would it be for the sake of procedural justice, allow the healthcare provider to put forward a defense? If not, why not? Mr. Chen, I have already replied to that. I have already given a written reply. Can you say orally to members what you mean? Because very often, new bills put emphasis on procedural justice. When you suspend or revoke registration, the usual practice is to give the opportunity for the affected person to state his case, and this will be usually in the law. Mr. Chen, we have already given a written reply. Yes, we did not exactly study the paper because we thought we would come to the clause first before we examine your reply. Well, we think suspension may occur from time to time because of irregularities. And we say that in clauses 19 to 22, there may be many scenarios under which we might have to suspend the registration of a certain clinic or professional. Now, if that professional or that organization does not provide healthcare anymore, or its nature of business has changed, and if we discover that the computer system is very problematic, now since there are very different scenarios that may be likely, and so that we have to suspend the registration of the healthcare provider, And since scenarios may vary a lot, in certain situations there may be an emergency situation, say the computer system extremely problematic, and at the service location irregularities are taking place, and we want to suspend the license immediately, and maybe we don't have time to consult the person concerned. But I believe in the majority of situations, we would state our suspicion to the provider and ask for an explanation first. We would certainly inquire and ask for clarification. We believe that procedure would already afford the opportunity to the provider to state his defense if there is one. And that is why we have two different categories. One, revocation. Two, suspension. We would first suspend, and at the stage of suspension, if justifications can be put forward, then we would reinstate the registration. But if we are not satisfied with the explanation advanced, we will revoke the registration. And later on in the clauses, you will find that people can appeal to the Administrative Appeal Board. If under the ordinance, if it is said that the Commissioner's decision is not fair, then an appeal can be lodged with the Administrative Appeal Board. Any questions? Legal advisor, anything else from you? Actually, to me, you say, of course, there is an appeal channel, but apart from that, the Commissioner seems to have all the powers in his hands to make decisions about these matters. And suspension, you don't mention a time period. Could there be a protracted period of suspension, for example? Just now, you said within the period of suspension, if you think the problem has been cleared, then there would be reinstatement of registration. But then in the bill, we can't see there is any time limit for suspension. There is no guarantee about that. No, we don't talk about the longest period for suspension because cases vary. The suspension period can be very long or very short, depending on the cases. And the healthcare provider might have to do something to rectify the mistakes, and they may take 2, 3, 4 months, and it is hard to say. That is why there is no period provided for suspension. We don't say if you do not rectify the situation within a month, we will revoke your registration. We don't want to be as specific as that. Chairman, can I add one word? My understanding of the administration's explanation is that during their liaison with healthcare providers, they would seek to communicate with the providers. But then when it comes to the legislative process, because of the consideration of procedural justice, if there is no express provision providing a chance for the registered person to advance a defense, maybe he wants to give you a written explanation to explain why you should not suspend the registration. If the opportunity is not provided in the law, that may become a cause for judicial review. That is why in the legislative process, the usual practice now is to state that in the law itself. This is for consideration by members and the administration. Dr. Low Wai Kok and then Dr. Joseph Lee. Thank you, Chairman. We have a few clauses on suspension of registration or revocation of registration, etc. This reminds me of something. At present, you take care of appeals. In Part 7, you will amend the AAB ordinance in order to add in this particular piece of legislation, so the AAB can also process appeals arising from this piece of legislation. Now, this reminds me of something. We have just completed the scrutiny of the district cooling bill. There is an independent appeal mechanism in that bill. There will be an independent appeal board set up just to take care of district cooling matters, including laymen and professionals. Of course, we know we need to do something specific for that piece of legislation. I'm not saying that it is not feasible for you to use the AAB channel. I'd just like to ask you to explain why you think the AAB channel is sufficient. Because if we are talking about sharing of EHR records, there may be many technical matters involved and many different stakeholders are involved, like the recipients of healthcare service and the providers. Why don't you consider setting up an independent appeal channel instead of going for the AAB channel? Mr. Chan. Thank you, Chair. Generally speaking, when we think about different appeal channels in the law, we have indeed considered what Dr. Low said. In certain circumstances, we think there should be a specific or independent appeal channel, but sometimes we also think that it's all right to refer appeals to the AAB. Under this bill, the Commissioner will make decision as to how to process the application of patients or how clinics perform. These are administrative functions, and the Commissioner will be working on the basis of actual administrative considerations. Therefore, we have chosen to go down the AAB route. The AAB now is responsible for appeals under many pieces of legislation, and those appeals are very similar to the nature of appeals under this bill. Those appeals are not so professional or specific as to require an independent channel. This is why we have decided to go down the AAB route in order to tackle the suspension or cancellation cases. We actually don't expect there would be too many appeals, because if they act according to the bill, there shouldn't be too many such cases. This goes to explain why we have chosen the AAB route. The legal advisor asked whether it would be unfair to the affected organization or provider without giving a chance for defense. I like to say that in the bill, we envisage perhaps there may be a plethora of situations under which suspension is necessary. Say, for example, if we should see that an organization declares there are 10 healthcare professionals engaged, but then none is working there, then at that point we might want to suspend the registration. And if we think that the computer system is problematic, we might have to suspend the registration at once. In those circumstances, it will not be possible for us to go through the entire process of liaison and defense, etc., before we suspend the registration. This is about security, as you may understand.
I think the legal advice is not referring to the cases whereby revocation or cancellation of license are needed. She was referring to whether there are clear appeal mechanisms so that to prevent judicial reviews to be lodged. Of course, you may have many reasons for cancelling the license or registration, but still, the aggrieved parties may like to lodge an appeal. I'm not talking about appeal or the AAB. I'm saying, what I'm saying is that if the commissioner wants to suspend or cancel the registration, but before the cancellation, it should be stated in the bill that the aggrieved party can have a channel of redress or appeal. Well, this should be explicitly written in the legislation. With or without this clause, there is a difference. Legal advisor would like to make a distinction between a redress and appeal, right? Now, we do have the AAB provided in the bill, and then the legal advisor is saying that the aggrieved party should be given a chance to put up a defense before the cancellation. We said that before cancelling the registration, we would make inquiries, and we must have strong reasons for the cancellation, and we should notify the party in writing for the reasons of the cancellation. So if we have to write in another clause stating that, say, 7 or 14 days should be given to the provider to put up a defense before the cancellation, and I don't think that's a reasonable approach. These are two different things. You may give him in writing, setting out your reasons for cancellation, but then this is all together a different thing, that you should be giving the chance for the aggrieved party to put up a defense and to state why you shouldn't be cancelling my registration. Should we add in a clause that the healthcare provider should be given a chance to give explanations? I believe that you would do it anyhow, even if this is not written down in the bill. But the legal advisor is advising that you should put that down as a clause in the bill to give more protection to the healthcare provider. We would do that anyhow, and say if somebody complains that the clinic or the provider has closed down, and somebody complains that the 4 healthcare professionals have been fired or sacked, of course we would do investigation to verify such facts. We would do that anyway, but whether we should be putting it expressly in the bill, then that's a different matter. The legal advisor advises that you should put it down expressly, because this is being done in other pieces of legislation, or else you will be challenged. So to make sure that the bill is foolproof, you should do that. We have actually thought about this when we drafted the bill. Perhaps I'll defer to Ms. Lee to take that question. We have considered that point. Well, not everything, say, is set in stone in these two clauses on suspension and cancellation. Let me cite an example. If the system of a healthcare provider has his system hacked into by somebody, and that will affect our main system, of course, we have to suspend their registration. If we have to put in the legislation that there is a clause that the provider will be given a chance to give explanation, then that will affect seriously our ratification measure. And sometimes an HCR can personified to be somebody else, and so that certain information can be uploaded to the system. If there is such a case, then we should also immediately suspend the registration and not give the person a chance to the person to make explanation. So in terms of protecting privacy and protecting the security of the system, we must do that. So that's why we ought not to lay that in the clause. Of course, in our investigation inquiry, we would seek information from the aggrieved party for clarification, and we should not put it down as a clause in the bill, or else we will not be able to deal with emergency situations in the future. So let's not dwell more on this point. Dr. Joseph Lee, I'm not here to debate with you. The legal advisor has come up with a very clear view. She was talking about procedural justice, and the administration has not responded to that. As a legislator, I must also point out the checks and balance in the system. You talked about the technical arrangements, how many days would be needed, and so on. And say if the computer is problematic, people claim to be there are no longer there, then that's all right. You can stop the suspension immediately. But then in the bill, no clause is included on redress and appeals. And that means the commissioner is very powerful and has all sorts of authority. And in the bill, it says that there is a code of practice. The commissioner has the power to issue a code of practice. People are very concerned whether the code of practice will give great power to the commissioner, and that people will not be allowed to seek redress or appeal. So, Ms. Choi, can you improve the bill so that you can protect people's interest? I think everything has to be written down in black and white. The legal advisor raised the point about procedural justice, and I'm also concerned about checks and balance. The Commission has the power to revoke or suspend the license, and we must think of some ways to protect the aggrieved party's interest. Ms. Sito, I believe you are on the same point. I'd like to thank the legal advisor for making that point. The DOJ's colleagues mentions about emergency situations when there is hacking into the system, you have to protect the computer system, and so on. Well, protecting the system and penalizing someone are two different matters. We can accept that you can suspend the registration of the healthcare provider when there is hacking into the system, but still you have to set out the redress mechanism for these healthcare provider, or else we'll be missing something in the entire judicial process. The government likes to talk about there are precedents, and then we accepted that. Then that's not acceptable to me. I trust that you are not intent on destroying the system, and then you do have the intent to give them a chance to seek redress. Well, if that is the case, why don't you write it down in black and white? You talked about hacking in the system, and I think we can discuss how that can be dealt with. But we cannot compromise procedural justice just because there is one particular scenario that's going to happen. Dr. Lo Wai Kok, I would also like to make an analogy to the District Cooling Services Bill. As I said, you said you would use AAB, the President AAB, as the appeal mechanism for this EHRSS. I don't have any objection to that. But when we come to the scrutiny of that part, perhaps Mr. Chen can give more explanation on the procedures now adopted by the AAB, so that we think that we can be convinced that it is an appropriate channel and there will not be any problem with procedural justice. Well, even using that AAB, I think in clauses 22 and 23, something specific should be mentioned about the opportunity to make an appeal so that it can tally with the Part 7. And you can say something about appeals can be made and then the appeals will be dealt with at AAB. So that gives everyone a clear picture that there is an appeal mechanism. With regard to the District Cooling Services Bill, an independent appeal mechanism is being proposed. And the provisions are there also clear. The Commissioner can suspend the system supply, and then the aggrieved party can make an appeal. But during the suspension period, the services will still be provided. What the same should apply here. And I think we should also make specific provisions on these aspects in the bill. Perhaps that is already covered under the AAB ordinance. I don't know. So anyway, when we come to the discussion of that part, can you give us more information so that we know the exact procedures with regard to AAB? And then we can be convinced that we can still use this mechanism to deal with the complaints or the appeals under this bill. I think the members have raised very similar demands. Mr. Chen. Thank you, Chairman. Dr. Low referred to Part 7 on the AAB ordinance, and can we add in a clause here in the earlier section to draw the healthcare providers' attention that they can use the appeal mechanism referred to in Part 7 to lodge an appeal? I can study that together with my colleagues. Secondly, sometimes we have to make immediate action, take immediate action to suspend the registration. Perhaps somebody impersonates other people, or the computer system is being hacked into. So that's why we came up with proposals for two handling methods. One is suspension, the other cancellation. We do need the power to suspend the registration. If we take other examples like the membership in a club, a credit card holder, and so on, very often the companies do have the power to suspend the cards or the membership to protect your interests.
This is not the same as permanent cancellation or revocation. Something permanent would mean it is a heavy penalty. Is it that we can talk to the DOJ again to see whether there is any room for maneuver, so we can ask people to provide justifications or information? I think we have stated our views quite clearly, and we will go back and consider the ways to do it. Well, just now the legal advisor says that she would like to seek some clarification. Chairman, I am going to talk about the Chinese wording. I was reminded by the chairman that actually we were talking about the chance to make a representation to the commissioner. In other words, if the commissioner discovers an irregularity and he wants to cancel the registration, we are saying that there should be a chance to make a representation on the part of the person affected. So he or she has the chance to explain to you why it is not an irregularity. And after the commissioner considers the justification, then he can inform the person in writing why he still wants to cancel the registration. But as to Dr. Lowe's suggestion, there may be circumstances where suspension has to be done immediately. Sorry, speaker not coming through. I think the legal advisor is saying that it's all right for you to suspend the registration right away, but then there should be a protection of my right to make representation. I think it is about check and balance. And the advantage of having this in the law is that when members of the public read the law, they will know they have this right, or else they might not know. And I'd like to point out that apart from healthcare providers, in clauses 10 and 11, there are relevant clauses on healthcare recipients as well. Maybe you can give consideration to both. Yes, Part 7, we can refer to that as mentioned by Mr. Chan. In fact, you can go to the AAB for both suspension and cancellation. But of course, the legal advisor is mentioning something else. It is not that representation should only apply to cancellation. The spirit is really that people can go to the AAB even for suspension. Yes, Chairman, thank you. My colleague was reminding me that, yes, Part 7, we would add our bill to Part 7, and then in another clause, there are miscellaneous provisions saying that the healthcare recipient or the provider can act according to this bill and appeal against decisions made by the commissioner. And during the period of appeal, the commissioner's decision will stand. Say if I have serious concern that a person claims himself to be a famous singer, Andy Lau, but in fact he is not, then we should be able to suspend the recipient's registration. When we come to clause 55, we can talk more about this, but since we are on appeal, I'd like to mention this. I know the legal advisor is not really talking about the appeal channel. I think what she is trying to say is that before we suspend or cancel registration, it seems there is no provision for the other party to advance any justification. I was trying to say that in certain cases, we just cannot wait for that process to take place before we suspend registration. That is why we are not providing for it in the law. But I will go back and think again. Between suspension and appeal, can we do something? Because cancellation is very serious, but suspension can be for as short as 3 hours in certain cases. So we'll go back and see whether there is something we can do between suspension and cancellation. This part is on rights. And maybe here we should mention in this part that people can refer to clause 55 and part 7 to lodge an appeal with the AAB. And I will provide a paper to explain the work mechanism of the AAB. Ms. Choi. I'd like to add, please. When the Commissioner applies clauses 22 and 23 to suspend or cancel registrations, well, before that, I think clause 50 is relevant. If you read carefully, 50 bracket 1, 50 bracket 2. Those are aligned with 22 bracket 1 and bracket 2. It says, if the Commissioner is of the view that there are circumstances suggesting the happening of an event specified in subsection 2, the Commissioner may in writing require a registered healthcare provider to provide the record or document. And it goes on to say that is or may be relevant to the event and that is in the healthcare provider's possession. And the healthcare provider might have contravened a provision of this ordinance or a provision of the code of practice, etc. The intent is that before the Commissioner suspends or cancels a registration, the Commissioner would already contact the relevant healthcare provider to ask for the submission of papers or records. So the Commissioner will not just decide on cancellation and cancel registration right away. In fact, there is this process. Thank you, Ms. Chai. Ms. Sit Ho, followed by Dr. Joseph Lee. Chairman, I'd like to ask Mr. Chan and also the DOJ a question. I'd like to ask how they first considered this issue. If it is for technical reasons, you want to protect the computer so that the healthcare provider should not be in the system anymore because he might be doing things to affect the workings of the system. Now, that is a technical point. But then when you want to suspend a registration, maybe it is for the person's behavior or misconduct. So these are two things. One is a technical necessity. The other one is done on the basis of conduct or behavior, which is more serious. When the Bureau or the departments first considered this issue of suspension and cancellation, what was your thinking? Just now the DOJ told us about the technical necessity, but what were your other considerations? I think we should be fair to you to let us know how you went through your thinking process. Maybe Mr. Chan can be asked to explain the differences between suspension and cancellation. No, I'm talking about suspending someone from the system so that he cannot sabotage the system. Well, yes, that means suspension. But Ms. Chai just said that there is another clause. Well, the administration is pointing us to Clause 50, Clause 55, and Part 7. Well, yes, I think they should be taken together. But what the legal advisor is saying, if there can be clearer provisions, there will be a lot less controversy. And when people read the law, they will come to Clauses 22, 23 first, and then they will already be informed of their rights. And the legal advisor is saying that there may be a better way of drafting. So can you supply us with papers after considering the situation to see whether you would like to bring in improvements? But Ms. Sito is asking another question. That is suspension from the participating in the system. Well, I'm not sure whether it is a different question. Well, yes, it's related. But the DOJ mentioned a practical situation about technical necessities. As the officials were saying, somebody might impersonate you in using your credit card, so the credit card will be suspended. But do you want to use that serious word, cancellation? Will there be different levels of actions that you can take? Well, a suspension means it is time limited. Mr. Chan, let me explain what we thought about when we drafted the situation. We think there can be two stages. One, Clause 22, suspension. The healthcare provider would no longer be able to access the system. We don't cancel the license for the provider to see patients. So Clause 22 is the first step. We suspend your registration, so you cannot access the records as in healthcare provider in the system. And Clause 23 is cancellation. That is forever. We will not allow you to access the system anymore. We know that there can be different extents of seriousness. Cancellation is serious because it is forever. But clause 22 is just for the time being. Maybe we need time to do investigation and the other person may need time to advance explanation. And it depends on the merits of each case, whether we would go for suspension or cancellation. I think suspension would apply to the majority of cases. That is why we have separated the two into two clauses. That is what we thought about during the drafting stage. And we were just giving you examples as to why we might need to do immediate suspension. And my colleague was trying to say there could be a virus in the computer system of a provider and our entire computer system may be sabotaged. And in the end, we have in mind patient safety because the system holds person's information. If the information or particulars can be cancelled in the entire system, then that is not in the interest of patients. That is why we would like to have the authority to do suspension. And in fact, we have the same right applying to healthcare recipients. We can suspend or freeze the eligibility of the patient. As I said, people might impersonate other people when seeking medical care. And that is why we should be able to freeze or suspend for the moment the registration of that recipient. We have separated the situations into two clauses considering their severity. And in the end, we have in mind the interests of patients. This is our rationale. Chairman, the healthcare provider may engage in misconduct. That is quite different from his computer system being hacked into, because in that case, the provider is a victim. I hope you will go back and think about how you want to treat these two very different scenarios. Right, that is what Mr. Chen will do. Dr. Joseph Lee. I think the legal advisor's point has not been addressed. From what I understand you to be saying, well, the law draftsman talks about the appeal mechanism in Clause 55. We don't have a problem with that. And Clause 50, it says the commissioner should have evidence to base on before deciding on suspension or cancellation. We don't have a problem with that either. But what the legal advisor is saying that in this part, we cannot see the exemplification of procedural justice. This is the point we want you to consider. And also, this is a new bill, but this type of legislation is not new. The legal advisor has pointed out that the usual practice is, in fact, to protect the administration so that there will not be any loopholes, so to speak, in the law affording judicial review. And therefore, she's advising you to tackle the point of procedural justice. You go back to think about what clauses you can include here. I'm not a layman. I cannot give you any advice, but this is really to protect you. Okay, you say there are checks and balances in clauses 50 and 55. I don't want to quibble with that either. But here in this part, perhaps you want to do something to protect yourselves so that people will not likely take you to court for judicial review. Legal advisor.
Anything further from you, legal advisor? I have a new question. Mr. Chan, can you reply in writing? If you do consider amendments, please give us a written reply. Well, if that's all right, then the legal advisor has another question. Has to do with these two clauses, 22(1)(d). And that has to do with the factors for suspension and cancellation 1 year. And that is the registration may impair the security or compromise the integrity of the system. That has been a point mentioned by some members. Can you specifically tell us what this refers to? Because it is broadly drafted. May impair the system. The system is massive in scale. You talk about security of the system and the integrity of the system. And this is included not only in the cancellation part, but also the suspension part. My question is, what exactly are you referring to here? Can the government explain? For suspending and cancelling the registration, would you be more specific on the factors to be considered? 23E, cancellation, and 22(1)E, the wordings are the same. In 22(1), it says that the commissioner, if the commissioner reasonably suspects, then he may take certain actions and he may suspend the license. But for 23, it says that if the commissioner is satisfied that the following conditions are met. In other words, he is satisfied that the system, that the registration may impair the security of the system. So we have to look at subclauses 1 of the 2 clauses. One is reasonably suspects and the other is satisfied. So that's the first part. Second part, the legal advisor would like us to explain the registration may impair the security or compromise the integrity of the system. Perhaps I'll defer to Dr. Zhang or Mr. Chai to tell us some examples. Dr. Zhang? Hi.
I mean, this is quite a broad area. It's hard to. I don't think it's possible to list out all the various ways that a system could be impaired or compromised, because hackers are very inventive people. But just to give some examples, for instance, the computer system that the provider is using could have been infected with something. It could have been taken over by something, and we can see that unusual activity is happening on that end. So we feel that it's necessary to immediately stop the system from accessing our system. So that's one very simple example. Or we see a strange pattern of access where that system is trying out different Hong Kong IDs and trying to access different patients. So we don't know why that's happening. All we can see is the activity. It could be somebody doing it. It could be the computers doing it. It could be computers controlled by somebody else doing it. So because there's so much variation in how these sorts of attacks can happen, we can only say that when we suspect there is some threat to the security or integrity of the system, we have to take action. I mean, I'm not sure if we're being asked here to list all the possible ways that a system could be compromised, or all the ways that we might suspect we could see such activity, because this will change over time as new forms of computer attack occur. I'm not sure if we're being asked to be very more specific, because I don't think it's possible. We can't guess all the ways that security or integrity can be compromised, because there are infinite varieties and new ones are being invented all the time. I'm not sure if that answers the question.
係好困難嘅，因為我都覺得你好困難係寫晒所有。
I think it's very difficult to list out all the scenarios. Of course, it is now broadly drafted in terms of the wordings. And in 22, you said reasonably suspects. Then it's also somehow vague. You may suspect that the computer has a virus, and also there may be problems with the network, and there may be problems with the applications. So there may be so many different scenarios. And Dr. Zheng also mentioned about man-made scenarios where a person may try to get access into the system, trying out different ID card numbers. So there are different scenarios. The legal advisor's question is whether the wordings should be more specific here. In other ordinances, I wonder whether there are similar wordings. Are those wordings clearer? And I also understand what Dr. Zheng said, that the types of attacks may change over time. So we can't come up with a specific list of scenarios because the hackers may be adopting new tactics to hack into the system, and that may not be covered by a list drawn up now. So, legal advisor, do you have anything to add? Dr. Helena Wong. If someone deliberately impair the security of the computer system, if the healthcare provider's computer system is damaged without his authorization, of course, and whose responsibility is it? If your computer is being hacked into, is it the computer owner who should be held responsible, or who else? How can the government ensure that there is security or integrity to the system? And how can you ensure that all the users can maintain the security and the integrity of their systems? This is altogether a different issue, and perhaps Mr. Chan can respond. Well, let's not forget our first question, and that is whether we should be more specific on clauses 23(1)(e) and 22(1)(e). When we come to clauses 41 to 46, that have to do with penalties, and 41 have to do with penalties or offenses relating to accessing the system. A person commits an offense if the person knowingly causes a computer to perform some other unauthorized functions. Now, if a hacker knowingly destroys a system of Mr. Chen Taiman, say, then we should be penalizing the hacker and not the owner of the computer system. Now, whether the owner should be held liable, we should see whether the owner has acted responsibly. Say, if he has used illegal software and he's dishing out the password casually, then he might be held liable too. Now, so 41 has to do with penalizing the person who knowingly does damaging to the system. Okay, we can come to that part when we go to clause 41. Let's go back to 22(1)(e) and 23(1)(e). Legal advisor, having heard Dr. Zhang's response, do you have anything more to say? Yes. First. Your wordings are may impair. The healthcare provider may invest into their own computer system. And you say that the registration may impair the integrity or security of the system, and then you cancel the registration. Then it seems that there is nothing much the healthcare provider can do. Well, you may not come up with specific scenarios, but can you come up with factors to be considered? so that the healthcare provider can be in a better position to explain his case. So that's the first point. Second point, in clauses 10 and 11, the same applies to the HCPs, i.e., when you want to suspend the registration or cancel the registration of the HCP, you will also consider whether the registration may impair the security or compromise the integrity of the system. I don't understand how a healthcare recipient's registration can impair the security or the integrity of the system. Is this possible? Mr. Chen or Dr. Wong would like to supplement. Mr. Chen, and then perhaps I'll defer to Dr. Zhang and Dr. Wong to add or supplement. Why do we use the word may? Well, this is a very important word. We need cancellation. We need the power to cancel or suspend the registration. We don't want to do it after a certain event has happened. If, say, before something happens and the Commission reasonably suspects that certain things are going to happen that may impair the system, then we must do something now so that to prevent something bad in the future. So we have to use the word may here. So that's why the word may is used, considering what I've said. Say, if we reasonably suspect or we are satisfied that your operation will damage our system or impair our system, then by doing that we can prevent the impairment. And Dr. Wong and Dr. Zhang, maybe I can add.
Question about how an individual healthcare recipient could threaten the integrity of the system. One example that I can think of immediately is if somebody fraudulently pretends to be somebody else, and if they were to successfully register, some incorrect data would be loaded up to the victim's electronic record, in which case anybody looking after the actual person who is being fraudulently impersonated would then have an incorrect record, and he would be treated incorrectly because the data is false. So in that case, it's the individual patient threatening the integrity of the system, at least for the victim. So that's an example of an individual. There may be others I can't think of at the moment.
Dr. Joseph Lee, I think we're almost time to finish the meeting. Perhaps I would extend the meeting a little bit, and we'll try to wrap up this point. The administration may have to come back for further information later on. Dr. Joseph Lee, I think that can be put clearly in the code of practice and not in the ordinance. 51 has to do with code of practice. And here, you can set that down clearly. And that is, if the HCP doesn't have a good firewall and somebody can hack into your system and do damage, then that can be written down in the code of practice. And, someone then can consider whether to do it after reading through the code of practice.
Well, if there is just a firewall, it might not do the trick. No, this is just by way of an example, but conceptually, I think it's important to tackle this gray area. And it may not be easy for you to write every detail into the law, but under Clause 51, you can try to do something about the code of practice. Dr. Lee is very correct. This is exactly what we think. To comply with this law, the operational details will be included in the code of practice as to how the system security can be damaged. There may be a lot of things that can do it, and you need a firewall, you need a security lock or something. We will be including those in the code of practice and the publicity guidelines. That is why we have separated it into two parts: the operational details in the code of practice, and the spirits, the principles, they will be in the principal ordinance. After clause 24, that is another part already. Can I carry on with clause 24? Yes, please. It is quite simple. In the registration of private providers, we state that a person can have different branches, say one in Sha Tin, one in Tai Po. When registration is done, it can be just one registration covering different service locations. Just now we talked about suspension of facilities, etc. Those would cover all the different service locations registered under the same person's name. If it is just one registration and several service locations are included, then the suspension or cancellation will apply to all service locations concerned. Okay, the administration will go back and consider the point of procedural justice and other considerations and come back to say whether there will be amendments. And no matter what, you will have to come back with a written reply. And also on the point raised by the legal advisor about security, can you clarify the provisions? I understand it may be difficult for you to further clarify the provisions, but please also respond to this point in your written reply. Okay. If there are no other questions on clauses 22 to 24, we have completed scrutiny of part 2. Part 3 will be taken up at the next meeting. The next meeting will be held on the 31st of March, again at 8:30. Thank you very much. Meeting adjourned.